Hi, I'm Wilfred Codrington, a constitutional law professor and a Brennan Center fellow. I'm talking today to Trevor Morrison about the tear that President Trump has been on, not even 2 weeks into his term. He's been issuing a spate of executive orders on a range of topics. Trevor is also a law professor. In fact, he's the Dean Emeritus of NYU Law and a member of Brennan Center's board of directors. Trevor, this week you wrote a great analysis in Just Security. A link to that analysis is going to be dropped in the show notes below. But in that analysis, you argue that President Trump's orders reveal that he really just thinks about executive power differently than his predecessors have. Can you, I guess, just talk a little bit about that, how he differs from past presidents in this regard?
Sure. I'm glad to be with you, Wilfred. Thanks for inviting me. Uh,
Of course.
yes, my NYU colleague Adam Cox and I wrote this essay that you mentioned, was published in Just Security. And in it, we focus on three areas of the many executive orders that President Trump has signed in his first 2 weeks in office, as you mentioned. And they cover a wide range of topics, of course, from immigration to citizenship to TikTok and much more. And then, of course, there are other executive actions that have been taken by his administration without being tied to a particular executive order. We don't claim to be describing all of them, but one theme we see across a number of them, especially the orders and proclamations relating to border enforcement, and his executive order relating to birthright citizenship, that is, who born within the United States can claim citizenship because they were born in the United States, and relating to TikTok, that those executive orders do have a common theme. And it's that the president is asserting an authority to act. And by and large, he's saying that the Constitution itself gives him authority to act. That's not unique. Every president asserts some amount of authority to act empowered directly by the Constitution, in particular by Article 2 of the Constitution, which is what establishes the executive branch and gives the president the executive power. What's unusual is that Trump is asserting a presidential power to act in ways that are clearly contrary to statutes, to laws that Congress has passed. And he doesn't even seem to be making an effort to justify the ignoring or the violation of the statutes. He's just acting in the face of contrary statutory command. Now, it's not like we've never seen that before. And in fact, the Supreme Court's separation of powers jurisprudence gives us a framework for thinking about this. Maybe the most important contribution to that framework is a very famous concurring opinion that Justice Robert Jackson wrote in a famous case called Youngstown. It involved President Truman's order for the executive branch to seize control of steel mills across the country in order to ensure production of steel during the Korean War. And this was at a time when there was a thought that maybe some kind of labor unrest might disrupt the production of steel. Supreme Court said President Truman did not have that power, even though he said it was necessary for national security. And Justice Jackson in particular said, when we think about presidential power, we really have to think about what has Congress said. The president, if he has authority to act, gets it either directly from the Constitution or from Congress. So when Congress authorizes him to take an action, the president has the most power he could ever have. If Congress has said nothing at all, the president might be able to take actions on his own initiative pursuant to his own constitutional authority. But when the president is acting in contravention, in violation of statutes Congress has passed, that's when the president's power is at its lowest ebb. It's not that he can never legitimately take action there, but in order to say that he has the authority to act in those circumstances, we have to conclude not only that the Constitution authorizes him to take action in that space, but that the Constitution says only the president can act in that space. So only the president can veto legislation, we know that. Only the president can grant pardons, we know that. The Supreme Court held about a decade ago that only the president has the power to decide whether to recognize a foreign government. So there are pockets of this exclusive power. The thing about these executive orders is they seem to be asserting an exclusive presidential power over a whole range of areas that are well established as being within the president's ambit, but also within Congress's authority. And he's just ignoring these statutes without even providing a justification in most cases, except that he wants to do something else. And so it's his own pursuit of policy aims, not being very troubled by the fact that they're violating the law.
Right. And so you just mentioned three different areas that you wrote about. I'm going to start with the TikTok bite dance
Sure.
order, right? Around the country and around the world, everybody's been following this roller coaster that has been this divestment law.
Mm.
Can you talk about that order, what Trump has sought to do, how he's trying to intervene with the act of Congress in that regard?
Sure. So last year, Congress passed a statute that you just referenced, requiring that either the parent company that owns TikTok, namely ByteDance, that either it divest its ownership of TikTok, or if it didn't, then effective January 19th of this year, TikTok had to cease operations within the United States. The reason for this is a concern that ByteDance is controlled or subject to control by the Chinese government. And therefore, through that control, the Chinese government could potentially gain access to private information of TikTok users and use that for purposes that would be contrary to the United States' national security. So a kind of data privacy and national security concern.
Right.
This was challenged on First Amendment grounds, and the Supreme Court held only 3 days before Trump was inaugurated that the statute was constitutionally valid. It rejected TikTok's First Amendment challenge to the statute. And then it went into effect on January 19th, 1 day before Trump was inaugurated. Trump had asked the court to pause the effective date of the statute so that he could try and negotiate a resolution to the issue, presumably by identifying a buyer for TikTok who was not affiliated with China. And by executive order, he basically did that. So the court upheld the statute took effect, but then by executive order, Trump just announced the statute's not going to take effect for 75 days. That'll give me time as a deal maker in chief to go potentially find a buyer or to figure out some other resolution to the national security concerns here. But he gave no justification at all for what gives the president the power to just suspend or say cancel a statute. I would emphasize this is not simply a matter of the president saying, as a matter of executive prosecutorial discretion, we will kind of under-enforce the statute for a period of time. He actually directed his attorney general to issue letters to the platforms that platform TikTok, telling them that during this 75-day period, nothing that they do in relation to TikTok violates the statute, when of course it does violate the statute. That is an assertion of a prerogative by the president to rewrite the law. And whatever one thinks about his policy preferences to negotiate a resolution to this in some other way, that policy preference can't be translated into law unless and until Congress amends the law or repeals the law, or at least the president comes forward with some account of his constitutional power that would justify ignoring it. All he has said really is that he's the president. The president is the commander in chief of the armed forces and has responsibility for national security. And he thinks that this issue should be resolved differently. So he's suspending the law to give him a chance to resolve it differently. The president in our constitutional system does not have that authority. A system that gave legislative and executive power and judicial power to one person would be a different kind of system. And the executive order, I think, can be read to reflect a preference on the part of the Trump administration that he be viewed as having all of that power.
Okay, so he's not setting enforcement policy priorities like previous presidents. He's trying to nullify this statute. It's gone to the Supreme Court. Now what? What happens next?
Yeah, that's the tricky part. And the answer to that kind of question will vary depending on the executive order. What the Supreme Court said in that decision that I referenced is that there is not a First Amendment problem with the statute. So TikTok's challenge to the statute lost, and therefore the statute took effect. As I say, I think the president does not have the lawful authority that he is now asserting to suspend operation of the law. The question is, can that asserted power by Trump be challenged in the courts? In principle, it could, But in our federal court system, the mere fact that an issue is really important and could use some judicial resolution doesn't necessarily mean that the courts can get their hands on it. We need to be able to identify a party with standing to sue Trump's suspension of the law. And thus far, no one has come forward to bring that challenge. And so we have, in my view, an illegal suspension of the TikTok statute, and so far, no judicial resolution.
We have a violation here and no remedy, right?
Yeah.
That's unfortunate. Okay, so the next issue, TikTok is, who knows what's going to happen there. But the other order that he issued relates to citizenship, right? And this one may be more problematic. It seems like he's not just flouting a series of statutes related to, citizenship that Congress put into enactment some time ago, but the Constitution itself. The 14th Amendment speaks about birthright citizenship pretty explicitly. Is that one unprecedented?
Yeah, I think what Trump has done in his birthright citizenship executive order is unprecedented. Let me just sort of unpack the constitutional and the statutory dimensions here. Both are important. So as you say, the 14th Amendment provides that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. This is an important provision in the 14th Amendment. Reconstruction amendments adopted in the aftermath of the Civil War. And among other things, this is guaranteeing citizenship to the recently emancipated slaves who could not claim citizenship prior to the adoption of the huge change in our law in our country that was wrought by the combination of the Civil War and the Reconstruction amendments. And so one aspect of this issue that raised by Trump's order is, what does the 14th Amendment mean when it says all persons born in the United States and subject to the jurisdiction thereof? The broad kind of understanding, and it's been a consensus, it's been reflected in court decisions, is that in the main, that means everybody, but just with very narrow exceptions. And the two exceptions that I think are implicit in Supreme Court case law, but actually are reflected even in the common law understanding of citizenship that predated the 14th Amendment, is that when we talk about subject to the jurisdiction thereof, the people who are excluded from that and therefore not entitled to citizenship as a matter of the 14th Amendment are the children of diplomats who are in the country in their capacity as diplomats. And so the diplomats have a kind of themselves immunity from the application of US law while they're within the country, and their children therefore could not claim citizenship just by virtue of the fact that they're born in this country because one of their parents or both of their parents are here serving as diplomatic representatives of another country. And the other is children born of soldiers who are an occupying army, who have taken over US territory and are occupying it as a hostile force. If they have children within the jurisdiction, the sort of historical understanding would be to accept them because saying that they are not subject to the jurisdiction of the United States. That's the traditional understanding. Trump's executive order goes way beyond that. He says you're not subject to the jurisdiction of the United States for purposes of citizenship if your parents have entered the country as undocumented migrants, as what he calls illegal aliens. And it even goes beyond that. He says you're also not entitled to 14th Amendment citizenship if your parents are in the country and they themselves aren't US citizens, and they don't have a green card. They're not lawful permanent residents, but they're here just on, say, some kind of work visa or student visa. If those folks have a child within the country, it's not that they're here illegally, but even though they're here lawfully under a visa, Trump says, well, that category of people, they're also not subject to the jurisdiction of the United States. Now, that by itself doesn't make sense in lots of ways. These people in these categories sure are subject to the jurisdiction of the United States' criminal law, for example. Someone unlawfully present in the United States is expected to follow United States law, and they can be prosecuted for violating it. So too, someone who's here as on a student visa or a work visa. So he's trying to use subject to the jurisdiction thereof differently for citizenship purposes than for other purposes within our legal system. And I think he's got that interpretation of the 14th Amendment just flat wrong. And a lot of scholars agree, and there's a lot of scholarship there. There are some who try and construct an argument to justify reading subject to the jurisdiction thereof as accepting more people from being entitled to 14th Amendment citizenship. I'm not aware of any scholar who has defended drawing the line where Trump has drawn it. And it seems to me, as a matter of constitutional first principles, let alone precedent, it's indefensible. But the point I want to emphasize actually goes beyond that. Even if Trump were right in his interpretation of the 14th Amendment, he has a more fundamental problem, which is that everyone acknowledges that Congress has the power by statute to grant citizenship to more people than are guaranteed citizenship under the 14th Amendment. The easiest to understand example is that Congress has by statute said that if you are born outside the United States, but one or both of your parents are United States citizens, then you are a United States citizen. That describes me.
Right.
I was born in Canada. I grew up there, but my mother is an American, and I have United States citizenship from birth, not as a matter of naturalizing, but from birth. Congress can grant that citizenship, even though that category of people is not constitutionally guaranteed citizenship in the 14th Amendment. And Trump's problem, kind of like with the TikTok example, Trump's problem is that Congress has passed statutes here that by their terms clearly grant citizenship to everyone born in the United States, in some cases, no exceptions at all, at least written into the statute. In others, using subject to the jurisdiction thereof, but where it's been clearly understood by the courts over time that that means only the very narrow exceptions I described before, not Trump's broader ones. So here again, even if he has some ability to interpret the 14th Amendment differently than we've understood it these many decades, differently than the Supreme Court has understood it. And I think he does not. And in any event, his interpretation is wrong. His executive order doesn't even attempt to justify basically setting aside the statutory grant of citizenship to a much broader category of people than his executive order would recognize. Happily, unlike the TikTok example, this is readily challengeable in court, and multiple lawsuits filed by civil rights organizations and by states through their attorneys general in multiple jurisdictions immediately after Trump filed or issued his executive order. And a federal district court out in Seattle has already temporarily enjoined the executive order, calling it during a hearing, I think he said, flatly unconstitutional.
Blatantly unconstitutional.
That seems to me about right. And the parties that are challenging the executive order have made both of the points that I just mentioned. They've said Trump is wrong as a matter of the 14th Amendment, but you don't even have to get to the 14th Amendment. His announcement of who is entitled to citizenship by reason of birth in the United States violates statutes that confer citizenship more broadly than he would recognize, and he doesn't have the power to flout those statutes. I am very confident that this executive order ultimately will not be vindicated. I think that it will continue to be met with a very chilly reception in the courts. And if the issue even ends up at the Supreme Court, and it might or might not, I'm confident that this Supreme Court will say that Trump does not have the lawful authority to do what he did in the Birthright Citizenship order.
Yeah, and as you said, this federal judge was a Reagan appointee, called it blatantly unconstitutional, and he even questioned the legal acumen of Trump's advisors. So that's just getting shot down.
I mean, I'm teaching constitutional law to first-year law students, and I would be pretty disappointed if by the end of the semester, any of them thought that the executive order was defensible. You don't have to be a well-seasoned constitutional lawyer to see the problems with Trump's order on this one.
Well, I'm also teaching, and I'm looking forward to recommending this article once we get to executive power. So thank you for writing that. I want to get to the third issue before we end this, though, and it's about the border crisis, right? And you talk about the half dozen or so legal orders that Trump issued about the border. He's invoking terms like invasion to justify them. First, I'd like to know your thoughts about this sort of rhetoric versus argumentation. Does that carry any legal weight? Is it rhetoric, argumentation, legal argumentation, or something in between? And then second, I'd like for you to just kind of talk a little about the discretion that the law actually affords the president and how far Trump is trying to take that. It seems like he's trying to supersede the law, but maybe you can correct me if I'm wrong.
No, I think you've got it right. So there are provisions in our Constitution, or a provision in the Constitution, and statutes that Congress has written that say that if the president declares effectively an emergency, he can take actions lawfully that he couldn't ordinarily take. And there is a flavor of Trump's invocation of or his description of what's happening in the southern border as an invasion, as trying to sort of harness that idea. It's, I think, underlying all of these border-related orders is the idea that if there is an emergency in the form of an invasion, then the president has some emergency power to take action to stop the invasion that he doesn't otherwise have. The Constitution does say that the federal government has a constitutional responsibility to protect the states from invasion, and so he is invoking that authority. And he is also invoking a sort of range of statutory emergency authorities too, at least implicitly. But the problem, again, for Trump is that as a legal matter, the emergency authority he is saying he has, or the rhetoric of invasion and emergency, doesn't translate into the kind of legal power that he needs in order to justify all of these orders. Again, I'll refer us back to Justice Jackson in his famous concurring opinion in that Youngstown case, the steel seizure case. He made this point, and it was an important point that he was making in the middle of the 20th century, not long after the end of World War II, with the rise of communism and totalitarianism in Eastern Europe. Mm-hmm. And he made a distinction between our constitutional system and the systems of other countries, at least some other countries, on precisely this point. He said, except for what's called the suspension clause in the Constitution, which deals with the writ of habeas corpus, which can be suspended in times of rebellion or invasion if the public safety requires it, though we think of that power to suspend habeas as residing with Congress, not the president. Except for that narrow clause, our Constitution does not have an emergency power provision. It doesn't say that the president on his own can just declare an emergency and then act on a broader set of powers in light of that emergency. And Jackson said, here's why. The framers knew that if you gave the executive the power to invoke an emergency, on the understanding that the executive itself would then have a broader set of authorities, that it would be tempting to declare emergencies really frequently because that would give you access to this broader set of authorities. And for that reason, he said, the president doesn't have the ability to unlock a broader set of authorities directly under the Constitution. Congress has passed statutes that do grant the president broader power in certain areas if he declares an emergency, and that's consistent with the Constitution. But there's no statutory emergency power that would authorize Trump to do what he's doing in the southern border. What he has said there is that the invasion of people crossing the border without documentation is so severe that our statutory immigration framework, the Immigration and Nationality Act, is just inadequate to deal with it. And so because of that, he is operating beyond the statute. He is not complying with what the statute provides in terms of process to be followed to determine whether someone has entered the country unlawfully and how to remove them, the kinds of shutdown of the border of crossings at all. Many of the measures he's taking are, he says, necessary to deal with what he calls an invasion, but not authorized by law, and in many cases actually contrary to statutory provisions that Congress has put in place. He says, apparently, the emergency justifies him in doing this, but he, again, does not have the ability under our Constitution to declare an emergency for himself and then to exercise a broader set of authorities. And Congress, by statute, has not conferred emergency authority on him that would enable him to set aside effectively the entirety of the Immigration and Nationality Act, which is arguably the consequence of the set of orders. This too, like the Birthright Citizenship order, is challengeable in court. I think it's somewhat more complicated because it's not just one provision. It's a set of things he's doing or he's ordering need to be done. And so it will take some time, I think, to figure out the sort of most sensible posture to invoke the power of the courts to review the legality of what Trump has ordered. But I ultimately do expect judicial intervention there. And I expect his assertion of authority to fail. just like it has so far with the birthright citizenship order.
And just a final quick question, if you will, Trevor. What about the people? What should the people be doing, right? We can rely on some courts, obviously, this judge in Seattle, but then we also get like a Trump immunity ruling.
Right.
How should they be thinking about what they should do in this time? It's going to be a long 4 years.
Right. So, I think for many people, the issue that was top of mind as they went to the polls in November was or a set of issues around the rule of law, and the importance of preserving the rule of law. Um, I think there were others who had other priorities at the top of their list, and so they may have thought, Trump's involvement in January 6th, for example, raises real rule of law concerns, but I'm more immediately worried about inflation, the economy, immigration, something else.
Right.
Um, and I think people are allowed to set their priorities. But now that we are in the Trump administration, I think it's important for people who are concerned about the rule of law to make sure that their elected representatives know that the rule of law is a concern, and to remind their elected representatives that Congress has a role to play in checking the use of executive power. James Madison talked about the constitutional separation of powers in our system and said that we separate executive and legislative power so they can check one another. He said ambition must be made to check ambition. Well, Trump has been pretty clear in his first 2 weeks in this new term what his ambitions are. And we need leaders in Congress to stand up for the prerogatives of Congress, to stand up for the laws that they've passed in the name of the people. So I think the people across the country who are concerned about that set of issues need to remind their representatives that it's important to them and it's a part of their job as members of Congress to assert congressional prerogative and to demand that the president, if he's going to pursue his agenda, that's his prerogative, but he has to do it within the boundaries of the law, or to provide adequate justification for why, in some limited circumstance, he can act in ways that sort of supervene the law. He has not done that. And the people ought to insist that our representatives in Congress make him do it.
We need leaders in Congress. We need leaders in general. Great words. Thank you, Trevor Morrison, again, Dean Emeritus of NYU Law. As I mentioned, your piece is going to be dropped in the show notes. It's a great piece about his dictatorial powers. We look forward to seeing you again soon, Trevor, and everyone out there. Goodbye. Have a great day.
Thanks very much. Good to be with you.